Good morning, everyone.
Good
Morning,
morning,
Judge.
Judge.
Hi, good morning, Mr. Walker. How are you?
Yeah.
Hello, Mr. Finley.
Morning, Judge Mincy.
Let's see, who else do we have? Just the two of you?
Good morning, Your Honor.
Good morning, Ms. Duncan. How are you? Good
I'm
morning.
Good morning, Your Honor.
There goes your entourage, Mr. Walker. Mr. Finley, you by yourself? Or they left you by yourself?
I think I know Miss Helen was on a second ago. Let's see.
Okay, okay.
Yeah, we're all here. Me,
Oh, good.
Derek, Zach, we're all here. Hey, Judge.
Oh, good. Hey, good morning. How are you all? Okay, I see him. I'm reading names. Okay. Making sure I'm clear with everyone that's here. All right, we'll go ahead and get started. Good morning, everyone. I am Judge Regina Mincy, and this is the state all-purpose calendar of the Fulton County State Court for Tuesday, March 15, 2022. I want to remind everyone that this proceeding is being recorded and live streamed on YouTube, so the public can see this proceeding, and it will be over YouTube with the internet, which means that everyone should govern themselves accordingly. Again, I want to remind the defendants on this calendar that you have the right to remain silent. You should remember that anything that you say about the facts and occurrences, circumstances regarding your case will and can be used against you by the state. They are here, ready to prosecute, and they are certainly listening to what you're saying. So be careful, defer to your attorney, and listen to what they are instructing you to do. As you know, you also have a right to an attorney at this proceeding. Some of you may have private attorneys or the PD's office is representing you. So defer to your attorneys. Are we ready to get started? It looks like in courtroom 2.
Yes, we're ready, Judge. Good morning. This is
Good morning.
position
How are you?
26, Mr. Wilson.
Okay. 26.
Your Honor, the state is requesting a breakout room for this case.
Okay.
Myself and Mr. Walker, along with the PDs.
Okay. Should it be Miss Helen and whom else? Good morning, Miss.
Judge, good morning, Judge.
Good morning, Mr. Howard. How are you?
Good, good. If I can put me in that breakout as well.
I'm gonna get in the breakout too. We'll let you in. Let's see. Mr. Walker, you want to be in there as well, and Miss Duncan.
Yes.
Got all that, Miss Champion?
Yes, ma'am.
Good morning.
Good morning.
We lost an hour, so we're getting adjusted this week.
Hey, Mr. Jordan, is this Sergeant Johnson? Are you on the Zoom call for today?
This is Miss Champion.
Oh, hey,
Sergeant
Miss
Johnson.
Champion, how are you? I do apologize. I know the judges them are in a breakout session for this defendant, but we need to get his case done so we can get him back upstairs if possible, please.
Upstairs, I ain't upstairs.
Okay,
I'm
hold
right around
on.
the corner.
Okay, I
Don't
got
try to
you.
make it look like I'm a mental
Okay.
player.
Wilson, let it
All
go.
right, okay.
Do you hear me, Miss
All right.
Chaplain?
Yes, ma'am. Yes, ma'am.
Thank you, because if not, then we're gonna have to reset it. We're trying to get him done so we get him back to the court, please.
Get me up
Okay,
out of here.
I'll let her know.
Don't say back
Thank
to the
you.
floor. Get him up out of here.
All right, courtroom 2.
Yes, we're here, Judge.
Yes, Ms. Helen is calling there now. To see if she can quickly speak with Mr. Wilson. Is he willing to speak with her?
Come on, sit over here. Come on.
Okay.
Well, I gotta sit right here.
Because you gotta talk on the phone.
Oh, I'm about to
Okay,
say.
yeah.
So why can't the phone be in front of me?
Because we're gonna go to another case. I'm gonna let you.
That's retarded. I would like to see her face while I'm talking to her.
You're not gonna talk to the judge, you're talking to your.
Okay. Is there anyone else on the Zoom for the case of Mr. Joe Paul Wilson?
Taking them too long, we got stuff
We
going
have
on
next
here. Okay.
Position 12, Mr. Johnson.
What's the link?
Huh?
What is it? Pull the check back up from the front, Francois, please. My phone, no.
No, I'm gonna say my name. Cato Joe Wilson Jr.
All right, can we start with position 12? Mr. Johnson? Is that you in front of me?
Yes, it is, Judge.
Yes, ma'am.
Okay.
Okay.
This is case number 22 CR 001151J. Is it Savarse Nathaniel Johnson? You're charged with 1 count of battery family violence. And I understand that this case is a bond hearing.
That's correct, Judge. Or no, yes, that's correct.
Okay. All right. You want to go ahead and start, Ms. Webb?
Yes, Your Honor. The bond right now is set at, I believe it's 5,000 surety with the conditions of no further contact with Mr. Corey Johnson, stay away from the incident location at 3030 Continental Colony Parkway, apartment 1302, Atlanta, Georgia 30331, with no alcohol, drugs, or weapons as a condition of bond. Your Honor, in this particular case, which occurred on March the 1st of this year, Atlanta Police Department responded to a dispute call, and upon their arrival, they met with Mr. Corey Johnson, who informed the officers that he and the defendant are domestic partners. Mr. Johnson also informed the officer that he and defendant had a verbal argument during the afternoon, and while arguing, the defendant began choking him. Mr. Corey Johnson also informed the officers that he was able to break free from the defendant, where he was able to run outside and get help and call the police. In addition to, Mr. Johnson did show the officers a video recording of that incident, and their officers were able to see and hear the defendant choking Mr. Johnson, and Mr. Corey's telling the defendant, "Hey, you're choking me," and the defendant responded, "I haven't started choking you yet, and this is what you want." Mr. Corey did sustain injuries to his neck and chin, which were swelling, and he had scarring, Your Honor. Excuse me, Your Honor, I believe I misquoted the current bond amount, just so I can be clear for the
I think
record.
on the order it says 3,500.
Yes,
Good bond.
that is correct, Your Honor. It is $3,500 surety, excuse me, and not 5,000. In addition to, Your Honor, when the state we did originally request 5,000, but it was ordered by the court for 3,500. Your Honor, the defendant does have an open case for battery family violence out of Marietta from 2021. In addition, he does have additional parole violations, Your Honor, and he has previous FTAs on charges out of Florida, and where he FTA'd actually twice in the same year. When we first had the defendant on the calendar for his first appearance, we did reach out to Mr. Corey Johnson, but we were not able to make contact at that time, Your Honor. But we know that whenever there's an incident of a possible strangulation, we are always concerned, because cutting off the oxygen supply to someone can be life-threatening and at times fatal, Your Honor. So for those reasons, we're asking for the court to keep the $3,500 surety bond.
All right, Mr. Finley.
Yes, Your Honor. As previously stated, the bond is currently set at a $3,500 surety bond, and we are looking for a modification, Judge. Mr. Johnson, although I do recognize the allegations in Mr. Johnson's case, he is presumed innocent, as we know. He is originally from Florida. He has no one that lives locally, so he has no one that can attempt to bond him out. He himself does not have any money to bond himself out. So the only reason he was here was for Mr. Johnson, of whom he has no interest in having communication with. So he would abide by the no further contact, as he has been. Also, as we know, bond is not punitive, but rather to ensure Mr. Johnson's return to court. I did not see any FTAs, so he does respect the legal process in that way. And that's why, Judge, we are asking for a signature bond in this case, but if not inclined, a $1,000 surety bond.
And he's been in custody for how many days?
Your Honor, I have 14 days as of today.
Mr. Finley, since I didn't originally hear this case, do you briefly know Mr. Johnson's work history or anything like that?
Yes, Judge Mency. So previously, leading up to his arrest, he was working for the city of Marietta in their garbage disposal arena, if you will. So that's where he was working for the city of Marietta. And he does, I did say he is originally from Florida. He has no one here, but he does have a place to stay once he gets out. An address that I have that's on Jimmy Carter Boulevard.
And Your Honor, just for the court's records, the defendant FTA'd out of a Hillsborough County case from April the 2nd, 2015, as well as he had a contempt of court from May 29th of 2014 as well, but I am seeing that as an out-of-county warrant for the FTA, Your Honor, as well. In addition to, he also had another FTA again in 2015 out of July 16 from Tampa, out of Tampa for a marijuana-related charge.
All right, I will reduce his bond to a $2,500 surety bond. Same conditions, no further contact with Corey Johnson. Stay away from the Continental Colony Parkway, the apartment complex, and no weapons, drugs, or alcohol while on bond.
And that was 2,500 surety, Judge Mency, you said?
Yes, 2,500 surety, yes.
Thank you.
Thing that they that talk, that was
Should be reset.
Come on, Miss Anina.
My sister named.
Next, we have position 1, Mr. Anina.
I'm sorry?
Next is position 1, Mr. Anina.
Okay.
My mom.
And I put in the chat if I could. Oh crap! It never sent. I need to speak with Mr. Anina before his position is up. If I could.
Okay.
He can be last. Go to the next, because he got to speak to him anyway.
Position 18, Mr. Powell.
Yes.
Hold for 1 second. Here's the-
You can have a
Come on,
seat.
you can have a seat.
Yeah, I got the money to get out, but I refused.
Deputy,
Yes, Judge.
I apologize on position 12, Mr. Johnson. He's going to be reset back to the division judge, but I need to arraign him. Understand that he has not been arraigned.
Needs my card too.
Okay, Mr.
Is he still in the courtroom?
Yes, he is.
Can you bring him back up? I apologize.
All three of
That's
my
fine,
family
Judge.
members here is against me.
Yeah,
This is Mr. Johnson, position 12.
I know it. but I-
Yes, Mr. Johnson,
Yes, ma'am. I don't want to pay the bond.
I need to arraign you. This is case number 22 CR 001151J. Your charge is 1 count of battery family violence with the offense date of March the 1st, 2022. And I just reduced your bond to $2,500 surety bond,
Yes,
but I
ma'am.
also need to arraign you. And I need to let you know what the formal charges are that you've been charged with,
I'm not-
and that your case will be set for trial to the judge, division judge assigned to your case.
Yes, ma'am. Could you explain that? You said arraign.
No, I'm
Yes,
not.
that is where you're formally charged with those charges against you. I can read the accusation if you want me to read it to you as to what your formal charges are,
Austin, Carolina.
or you can waive the reading of the accusation.
Carolina.
Okay, you can read my charges.
Okay, I'll read it to you. Hold on just 1 second.
19, but I moved back, you know what I'm saying, because of the same, listen, see, you're not letting me explain. the situation happened before in 2020.
Yes, for position number 12. This is his accusation.
Then I said, boy, then my brother came and snatched the taser out my mama hand. And then he started coming towards me. I said, bro, if you tase me with that taser, I'm gonna fuck you up.
Thank you. All right, Mr. Johnson.
Listen to them. Huh? Go ahead.
Yes, ma'am. I'd like to speak with my counsel if I can.
I don't have no other family members.
Mr. Finley.
Hey, Bob,
Yes,
those-
ma'am.
But that's what I said this morning.
This is just an arraignment, reading you the formal charges that have been charged against you. And so it is not any admission of guilt or innocence or either way. It is just a formal reading of the charges, okay?
Yes, ma'am. You can go ahead.
So what I'm going to do is I'm going to read this to you, that you've been charged with a misdemeanor, 1 count of battery family violence.
Okay.
And the accusation reads as follows. I, Keith E. Gamage, Solicitor General for the County of Fulton, State of Georgia, in the name and on the behalf of the citizens of Georgia, do hereby charge and accuse Savarse Nathaniel Johnson with the offense of battery family violence, a misdemeanor. For that said, accused in the County of Fulton, State of Georgia, on or about March 1st, 2022, did intentionally cause scratches and swelling, visible bodily harm to Corey Johnson, who is the other person living in the same household of said accused, in violation of OCGA section 16-5-23.1 F1, contrary to the laws of the state, the good order, peace, and dignity thereof. It is signed by Keith E. Gamage, Solicitor General of Fulton County. I want you to know that the total maximum penalty of 12 months in jail or $1,000 fine is what you could be found, if you're found guilty, is what the penalty could be for this charge. So do you understand the charges that have been levied against you, Mr. Johnson,
That's up.
and what I've read to you? Okay, and how do you plead to this charge?
I'm sorry, could you repeat that again?
How do you plead to this charge?
That's why I want to speak to my counsel, man, because I don't want to plead out on anything right now.
Well, what I'm asking, if you don't, are you pleading not guilty?
I just
No, actually, I'm pleading guilty to the charge.
I'm gonna leave.
I'm sorry?
I would like to speak
I
to
just
my
wanna pack
counsel
up my shit
before I
and
plead out.
I'm not asking you
Tell them
to
that I wanna
enter
get
a plea. I'm
Okay.
not asking you to enter a plea today. I'm just reading the formal charges against you, and I assume that you're pleading not guilty at this time. Is that correct?
At this time, yes, ma'am.
Okay, all right. So at this time, you're pleading not guilty. I will accept that, and I have read the formal charges against you. And then after today, you can speak with your attorney as to how the future disposition of your case may go, okay?
Yes, ma'am. Thank you. And I also like to say, does it matter if I was never Mirandaized, or does that not matter?
That's something you need to speak to your attorney about. I'm only here to let you know what you're formally charged with
Okay.
and set your bond, okay?
Yes,
Those are
ma'am.
the only things, those are things you have to speak with your attorney about as you go further, okay?
Thank you so much, ma'am.
All right, thank you.
The one that I had on the initial appearance. Come on now.
Next, we have position 18, Mr. Powell.
Come
Come
on.
on, Mr.
All
Powell.
right.
Okay, well, don't play dumb with me though.
Nah.
Your Honor, this defendant has an extensive history. If pretrial could reiterate the history for the sake of efficiency, the state would appreciate that.
All right, pretrial. Just making sure you're there. Good morning.
Good morning, Judge. What position?
18. This is case number 17 CR 025111Y. Mr. Antoine Powell.
I
you're
don't,
charging.
is Miss Helen on?
You're right. We don't have a PD. Hold on a second.
I think she might still be on the phone.
All right, Mr. Finley. Okay, this is your case, right? Okay, I'm sorry, let me start over. This is case number 17 CR 025111Y. Mr. Antoine Powell, you're charged with 1 count of battery family violence with the offense date of 10/24/2017. And is this still going to be a non-negotiated plea?
Judge, this case is indeed one of Miss Helen's as well.
Oh, she is 15-27. I'm sorry.
Yes, Judge. Yeah, I am 1 through 14.
Gotcha.
Yes, ma'am.
So let's hold on, Ms. Duncan. I was hoping Ms. Helen would be finished by this time, but. Deputy,
Yes, Judge?
this is Ms. Helen's case. Is she still on the phone?
No, she's off.
Okay. Let's see if we get a message to her to see if she can.
We have position number 10, Miss
I got it.
Finley client.
Have position 10 in South Annex.
Ms. Milton, I do apologize, but can you all stand by for me, please?
Yes,
Thank
we
you.
will. Thank you, Deputy.
Ms. Milton, stand by for me, okay? I'll get you in. Come on, we gotta get you done.
We're back on position 26, Mr. Wilson.
Thank you. Stand by pre-trial. Hold on a second. All right, Joe Paul Wilson, this is case number 22 CR 001127B. You're charged with 1 count of simple battery family violence. And the offense date is February the 27th, 2022. And what do we have today?
Judge, we're going to be entering a not guilty, doing a jail jury and a bond hearing today, Judge.
Okay. All right, and does Mr. Wilson need to be formally arraigned?
Yes, Your Honor.
Okay.
And Your Honor, before we do the arraignment, the state would just like to reiterate that we're requesting this case is transferred to the competency calendar on Thursday for further evaluation.
It is when, my litigation manager is telling me that it is what date? The 24th. It's not until the 24th. Are you aware of that, Mr. Walker?
I'm aware it's every Thursday. I just want to make the court aware of the state's position. I know we didn't follow back up with another breakout room because he needs to be resolved. His case needs to be handled, but I did want to state on the record that we don't think our arraignment would be appropriate at this juncture because there are concerns, there are MH concerns, but
Okay.
I'll let the court proceed.
Okay. Oh, Mr. Howard and Miss Helen, there we go. All right, so what are we doing today? I understand that we're going to transfer it to the competency calendar, and I will not.
No, Judge, that's not our request. I mean, I'm assuming Mr. Walker's aware, but right, Judge, we don't believe at this point that process is going to be in place where we would need to put him on that calendar. That's for specific types of cases. It's more of an issue. We don't believe that that's what's needed based on the conversation we've had today. There's some other issues that we can explore with our client after today, but as far as the competency calendar, we don't believe that's where it needs to go right now. So we would just ask for a regular bond hearing today, and then we'll follow up.
Okay, there is already an existing bond on this case, correct?
Correct,
That's
Judge, a
correct.
3,500 surety.
Mhm. All right, Mr. Wilson, and what we're going to do today, and I've just called your case, and we're going to address your bond today.
Yes, ma'am.
And Mr. Walker, I'd like to go ahead and arraign Mr. Wilson.
I understand. I just wanted the court to be aware of the state's position. That's all, Your Honor.
Okay, all right.
What's your position? Bottom or top?
Oh,
Bottom.
Mr. Wilson, if
Yeah,
you
I
have any
need-
statements or any questions, we talked about this on the phone just a couple minutes ago. You can call me or talk to me. If not, we can try to reset it and speak.
Please,
No,
can
we
we-
good.
Can we move this along, please? I do apologize, but can we move this case along? Thank you.
All right, so Mr. Joe Paul Wilson, with this case 22 CR 001127B, are you going to waive the formal reading of the accusation? Or do I need to read it to you regarding the case that you've been charged with today?
What is she, could you explain, Miss Catherine?
Sure, Mr. Wilson Jr., she's asking you if you want to hear the accusation read out loud. Would you like that?
Yes, you can read it.
Okay. And I need to inform you that, remember, you have the right to remain silent.
I
Anything that
understand.
you state about your case can and will be held against you. I have to remind you of your constitutional rights, okay?
I understand.
All right, so hold on 1 second and I will read the accusation as to, and formally let you know what your
Miss Helen,
charges are.
You
Okay.
already know what I said about the accusation, right?
But Mr. Wilson,
I am only reading it to you. It is only a formal reading.
I understand that, but what I'm saying is, after you read the accusation, her as a PD is supposed to tell you what I already told her about the accusation. So I'm gonna sit back and I'm gonna let you read it though.
Okay?
Yes, ma'am.
This case, the accusation in this case reads as follows. I, Keith E. Gamage, Solicitor General for the Solicitor General for the County of Fulton, State of Georgia, in the name of and on behalf of the citizens of Georgia, do hereby charge and accuse Joe Paul Wilson with the offense of simple battery, family violence, a misdemeanor for that said accused in the County of Fulton, State of Georgia, on or about February the 27th, 2022, did intentionally make physical contact of an insulting and provoking nature with the person of Sybil Wilson, who is the parent of accused, by pushing her in violation of OCGA Section 16-5-23F, contrary to the laws of the state, the good order, peace, and dignity thereof, signed by Keith E. Gamage, Solicitor General. And so that is what it states. And I want you to know that the maximum sentence for this charge is 12 months incarceration and or $1,000 fine. And so again, you will be transferred, or your case will be transferred to the division judge. And how do you plead to this charge?
Ain't you supposed to answer?
She's asking you.
No, I'm asking you, how do you plead to this charge?
Not guilty.
All right, I accept your not guilty plea, and this case will be reset for trial with the division judge, okay? So that is the formal reading of your charges. All right, and then what else are we trying to discuss and take up with the court today?
Judge, we're addressing the bond.
Exactly.
Okay? And Miss Duncan, you wanted to give me some information or state some facts regarding this case?
Yes, Your Honor, if we could have pretrial read the history for the record.
All right. Pre-trial?
What position are we on?
26, Joe Paul Wilson.
One moment.
Thank you.
indicates 33 cycles. Last arrest was June of 2021 for possession of marijuana with intent to sell or distribute, possession of Schedule I controlled substance in Orlando, Florida. No disposition was listed on that arrest. Record does show the defendant has an open case pending in Fulton County for terroristic threats, case 20 CP 192095.
Okay.
Yes, Your Honor. Included in that history are, in the past 10 years, are arrests in 2015 for domestic violence out of Florida. In this case in particular, one second. The incident took place on February 27, 2022. The victim in this case is the defendant's mother. It happened at 85 Mount Zion Road, apartment 126. When officers arrived on scene, they spoke with Sybil Wilson, the victim in this case. She stated that her son, the defendant in this case, had grabbed her and pushed her into the sofa in the living room, and he left the location. At that time, the victim stated to the officers that her son suffers from MH issues and has diagnosis as well as issues with illegal drugs. She did state at that time she wanted to press charges due to him putting his hands on her and acting in an aggressive manner. She did not need medical transport at that time. However, we have since spoken with the victim of this case several times, and as we reiterated in the breakout room, the victim has severe concerns for this defendant's ability to not reoffend due to his violent nature and the issues we discussed in the breakout room. She said that he has been violent in the past and she fears that he may kill someone or someone may be forced to kill him because he's very violent due to the nature of that and due to the fact that his history is mostly out of Florida with at least 30 cycles, as the latest one being 2021, we're concerned that this defendant may also be a flight risk. And due to the fact that he does have an open terroristic threats case in Fulton County Felony Court right now, we would request that the bond remain as stated at $3,500, my apologies, surety. And we would request that there be a stay away from the victim's location. And his mother is also because his mother is listed as a witness on the felony terroristic threats, we'd ask for that stay away from the incident location, no further contact with his mother, the bond remain the same, no alcohol, drugs, or weapons at this time, Your Honor.
Okay. Ms. Helen?
Yes, Judge. This is a bond hearing for Mr. Wilson Jr., who's 36 years old. He has 4 children that he is a primary caregiver of, 2 daughters, 14 years old, 13 years old, 2 sons, 10-year-old and a 7-year-old. Prior to this event happening, he was working full-time RGIS company doing inventory for the past several years. So, Judge, we're asking for the bond to be modified to a signature. Right now, Mr. Wilson hasn't been able to generate any income while being incarcerated, so he cannot afford any surety bond, especially not one of $3,500. So we're asking for a signature bond. Judge, I did hear the history, but we are still asking for this signature bond. He is a proud father. He was working prior to this happening, and these cases are still open. The terroristic threats is still open. So we're asking for him to be given the opportunity to get out on the signature bond, get back to working, taking care of his family. And if the stay away from mom is still enforced, he understands that. He does not want to return to 85 Mount Zion Road, Southwest Atlanta, 30354. So that is why we're asking for that signature bond, Your Honor.
Okay. All right, I'm going to deny the request for signature bond. And I'm going to reduce the bond to $2,500 good bond, $2,500 surety bond.
Judge,
And
can
the
we
same
also ask?
conditions- Yes.
Go ahead.
And the same conditions stay in place. No further contact with Sybil Wilson. Stay away from 85 Mount Zion Road, number 126, no weapons, drugs, or alcohol while on bond. And also there was in the previous bond order, there's an MHET, and I want to still can keep all those same conditions with the 2,500 surety bond.
And Your Honor, we were just asking for a one-time escort with the sheriff so that when Mr. Wilson Jr. is released, he can just grab all of his belongings with an escort, the sheriff, from that address of 85 Mount Zion Road.
All right, and I add a one-time sheriff escort to that location, and it should be with law enforcement. You are not to return to that location, Mr. Wilson, or else you will be immediately arrested without law enforcement to escort you, all right?
Come on, Mr. Powell. Next, we have position 18, Mr. Powell.
Thank you. This is case number 17 CR 025-111Y, Antoine Powell. The charge is battery family violence. The offense date is 10/24/2017. And I understand, is this going to be a non-negotiated plea?
Correct, Your Honor.
Okay. All right, Ms. Duncan,
We would like the history read for the record for this case as well, Your Honor.
Ms. Harrison. $18.
Your Honor, he has a total of 47 cycles with history in Georgia and Florida. He has one failure to appear within the past 10 years, misdemeanor convictions, 2013 disorderly conduct, 2014 driving while license suspended, 2016 driving while license suspended and hit and run, and a 2020 driving while license suspended, in which he pled a nolo. He has one felony conviction, 2014 in Fulton County for forgery in the 4th degree, 17 counts. Nothing further to add.
Thank you. All right, Ms. Duncan.
Okay, Your Honor, this case took place October 24th, 2017. The victim in this case is Melissa James. My apologies. My computer froze. In this case, the two were in a relationship and he was her live-in boyfriend at the time. The facts indicated that the two returned home around 7 p.m. on the night of the incident, and they engaged in a physical altercation because around 9 p.m. they had been drinking. The defendant had a strong alcoholic odor on his breath at the time and had red bloodshot eyes. So they began to get undressed and fall asleep. And at the time that they fell asleep on the sofa, it was around 9 p.m. At around 10 p.m., the victim in this case woke up and she found the defendant in this case in the bed with her minor child. When she confronted the defendant about why he was in the bed with her minor daughter, an altercation ensued where Ms. James and the defendant began to argue, and the defendant struck her in the face. The victim in this case advised officers that the defendant became very agitated and they continued to fight in the room. And the victim in this case was thrown against the wall and punched more times by the defendant. The victim in this case also notified officers that at the time she was thrown against the wall, she did begin to bleed because she was 3 months pregnant at the time. This case is a result of a bench warrant. There is an FTA for a jury trial from December 2021, and this defendant is scheduled for a bond forfeiture calendar on May 5th of this year. The state, given the facts in this case, the violent nature of the facts, and the injuries alleged, we are requesting 12 months to serve, 90 days, credit for time served, 28 days, balanced probated family violence intervention program, no further contact with Melissa James or the minor child. Stay away from 4050 Morgan Road, which is the incident address, apartment 255, or wherever the victim resides.
All right, Ms. Helen, is that your understanding of the plea offer?
Yes, Judge, it's non-negotiated. The state is requesting 90 days. We're asking for time served in this case. Mr. Powell has been incarcerated for the last 24 days. And for actually, this case is 5 years old. For 5 years, Mr. Powell has no contact with Melissa Grace or her minor or any minor at all, honestly. And so also has had a stay away, has not gone near 4050 Morgan Road, apartment 255. That is why we're asking for time served. Yes, this case is 5 years old. At this point, it's here on the calendar because of an FTA. So when I spoke to Mr. Powell, I got an updated address of 5022 Upper Elm Street, Atlanta, Georgia, 30349 as a consistent address for Mr. Powell to receive all of his notices. So that's what we're asking for today, Judge. We're asking for the 24 days to be considered time served. We do not have an issue with the stay away or the no contact. For the last 5 years, Mr. Powell has had no contact with either party mentioned in this case.
All right. So Ms. Duncan, I'm going to not ask or order any additional jail time and make this a credit for time served. And then that will be the only change to the plea. Are we ready to take the plea at this time?
Yes, Your Honor.
Okay. Mr. Powell, can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
Okay, and I need to inform you again that anything that you state about the facts or occurrences of your case can and will be held against you. So therefore you have the right to remain silent, okay?
Yes, ma'am.
All right, and I'm going to ask you a series of questions in order to accept your guilty plea and the recommendations as read by the state, okay?
Yes, ma'am.
All right, and I have heard the state's recommendation. Is this your understanding of the plea offer?
Yes, it's my understanding, Your Honor.
Okay,
I'm sorry. Yes,
okay.
Your Honor.
All right, are you under the influence of any medication, drugs, or alcohol at this time?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Very satisfied, Your Honor.
All right, do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up or waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to a trial by judge or jury, whichever you prefer?
Yes, ma'am.
And again, are you prepared to agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes, ma'am. I'm not on probation, ma'am.
Okay. And again, do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am, I do.
And as to, again, the charge of battery family violence, how do you plead?
Plead guilty.
All right, I will accept your non-negotiated plea with the recommendations that the state read, which is 12 months to serve, 90 days, and then credit for time served, which was 28 days, and balance probated. You need to complete the family violence intervention program. You are to have no further contact with Melissa James or her minor daughter. And you are to stay away from 4050 Morgan Road, apartment 255, or wherever the victim and her daughter, minor daughter, may be residing. You're not to go around them while you're on probation. I will also waive 6 months of the probation fees.
Well, am I getting put on probation?
The balance is being probated of the 12 months after the credit for time served. While you complete, yes, because you have to complete the Family Violence Intervention Program. And I want to say, I believe that's a 12-week program. Was that correct, Ms. Helen?
It's 24 weeks, Your Honor.
24 weeks, thank you. That's a 24-week program. So you will be on probation until you complete that program.
Okay, I released today, you get on the program today?
Well, tomorrow probably, but as soon as you're released, get that information, go ahead and sign up. And yes, the sooner you get started, the sooner you can finish.
Yes, ma'am.
And Your Honor, I want to make sure.
I'm sorry, I waived the 90 days for credit for time served. So there, yes, I did.
Thank you.
I just want to clarify. So there's a year of probation. There's the Family Violence Intervention Program classes.
Right.
There's the stay away, there's the no contact. But are you saying that once he completes the Family Violence Intervention classes, it's non-reporting or?
Or is my probation done with when I finish?
Hold on, Mr.
Hold
Walker.
on, Mr. Powell.
Hold on, Mr. Powell, I need you to not speak right now.
Yes, ma'am.
Are we going to have him to do the full 12 months or will he go non-reporting once he's completed FVIP, Mr. Walker?
Non-reporting is fine, Your Honor.
Okay, yes, you will go non-reporting once you complete the Family Violence Intervention Program.
And sorry to
And
interrupt.
probation will explain that to you, but yes, Mr. Walker.
I just want to make sure that he has his initial report day. Probation has put in the chat.
Okay.
So I just want to bring that to you.
So that is in the chat. I'm not sure if he can see that. Are you able to see the chat, Mr. Powell? If not, your attorney will inform you of where you need to go on March 29th to report to the probation office.
Yep, so they're doing appointments now. So his appointment's March 29th. You got to report to 132 Mitchell Street, Southwest Suite 2A at 1:30.
What day is that?
March 29th.
Okay, okay.
Okay.
Yes,
I
ma'am.
think there may be a few changes due to COVID, but they're taking them by appointment.
Okay.
You can't just walk in there, okay?
Correct.
So go on that date and time and they should give you that information upon your release as well. But we wanted you to hear that on the record for now.
Yes, ma'am.
Thank you, Judge.
Yes. All
Thank
right.
you, Nancy.
All right. Thank you. Good luck to you.
Next, we have position 11, Mr. Harris. Judge, you're muted.
All right. I'm sorry. Thank you. This is position 12.
11, Mr. Harris.
Sorry, 11. DeAndre Harris. This is case number 17 CR 028059C. Mr. DeAndre Harris, you're charged with 1 count of theft by shoplifting. The offense date is 7/20/2017. And we are addressing what today, Ms. Webb and Mr. Finley?
Yes, Your Honor, this is just a bond hearing.
Okay.
That's correct, Judge.
Right. and we are not doing the formal arraignment today?
He could be arraigned, Judge.
Okay, all right. Let me hear the bond issues and then I'll do the arraignment. All right, go ahead, Ms. Webb.
Yes, Your Honor. This incident actually occurred on July 20th, 2017 at the Macy's at Lenox Mall, where the defendant was caught by an asset protection officer at that mall, at that store, attempting to walk out with a baseball cap. The store's management witnessed the defendant go in and out of the dressing room several times and saw him have a hat on with a tag on it. And when entering the fitting room, the final time, he exited out without the tag on that hat and proceeded to attempt to leave the store. When he was stopped by the asset protection officer and held until Atlanta Police Department could respond. When he was interviewed by that responding officer, he told the officer a false name and date of birth, including the name Dean Harris with the date of birth of December 23rd, 1999. Your Honor, the bond is currently set at $2,000 surety. We are requesting that the bond remain, as the defendant has already FTA'd on this charge prior to this, and he has a risk. We do believe he is a risk of reoffending due to his history. The defendant has several convictions, including a theft by taking out of the cab from 2015, shoplifting from the cab 2016, where he received first offender, but 3 months after that shoplifting, he had another shoplifting offense that April of 2016 out of the cab. He has a DUI obstruction and driving while license suspended from Gwinnett, another obstruction charge from the cab, and another charge that is none disclosed for the record, Your Honor.
All right. Mr. Finley?
Yes, Judge Mincy, as previously stated, his bond for this theft by shoplifting charge is set at $2,000 surety. We are asking for a signature bond, Judge. While I do recognize that FTA, I did really stress to Mr. Harris the importance of respecting the legal process in that way and showing up to court. And that bond is to ensure his return to court. He does have strong community ties, Judge. This is where he's originally from. His whole family lives locally. So we are asking for a signature bond, Judge, and if not inclined, then a $500 surety bond.
All right. I am going to rule that the surety bond be reduced to $1,000. And the same conditions will continue as the previous bond: no drugs, alcohol, or weapons while on bond, and a stay away from the Macy's at Lenox. And again, that's a $1,000 surety bond. All right. Mr. Harris, we're going to formally read the charges against you. Do you want to waive the reading, or do you want to hear the reading of the charges against you for an arraignment?
We can waive the reading.
Waive the reading? All right. And I just want you to know again that you're being charged with 1 count of theft by shoplifting under 17 CR 028059C. It carries a maximum sentence of 12 months incarceration and a $1,000 fine. And again, how do you plead to those charges?
Guilty.
I'm sorry?
Not guilty.
Okay. All right. I'll accept your not guilty plea, and you've been formally charged and noticed of the case that's been brought against you today. Okay. So therefore, you will be transferred to the division judge for further disposition of your case. All right.
Can I ask one question?
Briefly, yes.
I just wanted to know, when was the FTA get out?
You can discuss that with your attorney, Mr. Harris, because that is something he can go over with you in your criminal history. Okay.
Yeah, that's something we should have put together, because they're saying the FTA been put out. I've been in prison. I've been gone. So yeah.
Okay, we'll discuss that with the attorney and he can get that information to the proper people to make that correction or to deal with that matter, okay?
Yeah, yes, ma'am.
That's not the matter before the court today, but you can discuss that with your attorney. All right, good luck to you.
Appreciate it.
Thank you. That concludes this matter.
Hold on, Mr. Kemp. Next, we have position 13, Kemp.
Okay. This is case number 22 CR 001095C. Kenneth Kemp, you're charged with 1 count of battery family violence with the offense date of February 17th, 2022. What do you have, Ms. Webb?
Yes, Your Honor. This is going to be a position 13, a non-negotiated plea, Your Honor.
Okay. All right, is that your understanding, Mr. Finley?
That is correct, Judge. This is a non-negotiated plea.
All right, go ahead, Ms. Webb.
Yes, Your Honor. In Mr. Kemp's case, the state is recommending 12 months to serve, 45 days, credit for time served, 18 days, balance probated, family violence intervention program, a stay away from the incident location at 1374 Murphy Avenue, Southwest Atlanta, Georgia. No further contact with Ms. Bridget Traylor, and that's Bridget, BRIDGETT, Traylor, TRAYLOR, and 40 hours of community service. Your Honor, the state did request a breakout room for this case. There are some additional facts that we have received from Ms. Traylor that might influence the court's decision today.
Okay. And you said that Ms. Traylor.
Ms. Traylor is the defendant's mother. She did express to us some MH concerns, and we just want to make sure that those are properly addressed because they are reflected in the state's recommendation. In terms of the jail time to request a possible MHET based off of the facts that his mother gave the state, Your Honor.
Okay, and you all have been in contact with her.
Yes, Your Honor. During his first appearance, she did let us know that there is a condition there, Your Honor. If we want to discuss it in a breakout room with his counsel, to see whether or not it has been treated since he's been incarcerated. But when I checked, I have not seen anything, and she's concerned about his stability to return to her home, and that our victim advocate did inform her about mental health court, and she was agreed that she believed that he would be a viable candidate for that.
Okay, so is that part of the non-negotiated plea terms that you're transferring?
Correct, Your Honor. We wanted to present that to Mr. Finley to see if he knew of anything additional because I didn't have access or wasn't privy to that information as to whether he's been getting treatment since being incarcerated, but his mom was very adamant about advising our victim advocate that that is indeed needed because he does have a diagnosis for
Can we have this discussion offline because we're getting more into the details now.
Yes, all right. Let's go ahead and put us in a breakout room, Ms. Champion.
Okay, Judge, who all needs to be in the breakout room?
Mr. Howard, Mr. Finling, Mr. Walker, and Ms. Webb. When I break out, I break out of the room and break it up, but are they going to call each other, Ms. Webb, possibly? Are they still in the breakout room? I don't think they are.
They're still in the breakout room.
Oh, are they?
Your Honor.
Okay, good. Okay, I thought I messed up all of that by closing it out. All right, Deputy. Courtroom 2.
Yes, Judge, we're here.
Yes, Mr. Kemp's case is going to be reset to March the 22nd.
Okay,
Yeah, there are some matters that we need to address. So, Mr. Kemp, your case will be reset to March 22nd.
so his bond remains the same?
Yes.
Okay. Next, we have position 20, Mr. Spivey.
All right, this is case number 22 CR 001072C. Mr. DeMarcus Dion Spivey, you're charged with 1 count of battery family violence and a 2nd count of cruelty to children in the 3rd degree, both with an offense date of October 27th, 2020. Is this going to be a negotiated plea?
That's correct, Your Honor.
All right, Ms. Duncan, go ahead.
Yes, Your Honor, for the first charge, battery family violence, the state is recommending 12 months to serve, 60 days, credit for time served, 25 days, balance probated, family violence intervention program, 40 hours of community service, no further contact with Jasmine Martin, both common spelling, a stay away from 20 Lakeview Place, apartment 170 in East Point, Georgia. And for the 2nd count, cruelty to children in the 3rd degree, the state is recommending 12 months to serve, 50 days, credit for time served, 25 days, balance suspended, no further contact with the minor CM.
Yes, Your Honor, that is our understanding of the state's recommendation. We do agree to that recommendation, and we do stipulate to the factual basis, venue, and ID. We would just ask that it is balance probated, that at least 6 months of the probation fees be waived.
And then after he completes FVIP, are we going non-reporting?
I'd like for that to be the case if ASG Duncan is willing.
Do you have any issues with that, Ms. Duncan?
This defendant does have prior battery, family violence, and cruelty to children convictions. So the state will be opposed, but we would leave it up to Your Honor's discretion.
Okay. I'm going to just go ahead and have Mr. Spivey do the full 12 months. I will not grant that given his history. Okay. All right. So we're ready to take the plea.
Yes, Your Honor.
All right, Mr. Spivey, can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury? Okay. I think they may have to unmute you. I can't hear you.
Yeah, sure.
Okay. And I want to remind you again that you have the right to remain silent, that anything that you say about the facts and occurrences of your case can and will be used against you. So govern yourself accordingly and listen to your attorney, okay?
Yes.
All right. And you consent to proceeding in this manner with the Zoom format, is that correct?
Yes.
All right. And it is my understanding that you wish to plead guilty to the charges of battery, family violence, and cruelty to children in the 3rd degree. Is that correct?
Yes, Your Honor.
Are you under the influence of any medication, drugs, or alcohol at this time?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up and waiving your right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving your right to remain silent and not testify against yourself?
Yes, ma'am.
And that you're giving up the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you're prepared and agree to waive these rights today, is that correct?
Yes, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today.
Yes.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
And as to the charges of battery, family violence, and cruelty to children in the 3rd degree, how do you plead?
Yes.
All right. And you have heard the conditions that the state has agreed and stated in the plea, and that is 12 months probation, 60 days to serve, credit for time served of 25 days, balance probated. You must complete the family violence intervention program. There's 40 hours of community service and no further contact with Jasmine Martin, and a stay away from 20 Lakeview Place, apartment 170 in East Point, Georgia. And the second charge, again, 12 months probation, 50 days to serve, but credit for time served of 25 days. The balance will be suspended, and no further contact with the minor CM.
Yes, ma'am.
All right. So those are their conditions for bond. I will waive 6 months of the probation fees. And I think that concludes this matter. Is there anything else that the court needs to take up?
No, Your Honor.
Nothing further.
All right. Thank you.
Thank you, Judge.
All right. Good luck to you, Mr. Spivey.
Next, we have Mr. Lawson. He's position.
Is that 14?
Yes, it is. Thank you, Judge.
Uh-huh. This is case number 22 CR 001214D. Derek DeAndre Lawson. You're charged with 1 count of possession of a pistol or revolver by a person under 18 years of age, and second charge of obstruction of a law enforcement officer. And both of those offense dates are June 1st, 2021. And is this going to be a plea today?
No, Your Honor. This will be a jail jury bond hearing.
I'm sorry, bond hearing. All right, Ms. Webb.
Yes, Your Honor, and I just want to make sure I was checking Odyssey for the defendant's current bond. I wanted to make sure that, Your Honor, you had the bond, the current preset bond for Mr. Mr. Lawson.
I have 5,000 surety.
Okay, I just wanted to verify. Thank you. Yes, Your Honor, the state is recommending that the bond goes unchanged. And the facts of this case, excuse me, can you guys hear me? My computer just bleeped out. Okay, can you see me? Yes. Okay, I apologize. Yes, Your Honor, the facts of this case are last June at Greenbrier Mall, the Atlanta Police Department responded to a located stolen vehicle. The officers saw a group of males walk to the car, and when the officers approached the males, they ran and dispersed in different directions, including one taking off in the vehicle. The defendant ran inside of the mall where a chase ensued, and he was eventually apprehended and arrested inside of Greenbrier. The officers did locate the defendant with a pink SCCY CPX a firearm, Your Honor, a 9mm firearm, Your Honor. And the officers did release the defendant on a copy of charges and charged him with that possession of a firearm by a minor and obstruction. Your Honor, this defendant also has another open case for similar facts out of a case from College Park from just 4 months after this incident, on October 23rd, 21st, Your Honor, where the defendant is accused of breaking in and entering into an auto at the Quality Inn on Old National, Your Honor. In addition to, the responding officers did notate that the defendant is a suspect in several entering auto cases, Your Honor. And just for the record, the defendant does have an FTA out of Fulton for this charge, Your Honor, obstruction. Open cases for obstruction and theft by receiving out of Atlanta from 2021. He has an open case for financial trends, card theft, identity theft, theft by receiving, obstruction, fleeing, or attempting to elude a police officer, Your Honor. In addition to, he has another open case for theft by taking from Atlanta Public Schools from 2019. For those reasons, and we do understand the defendant is presumed guilty, Your Honor, but considering the facts of this case and the slew of open cases, Your Honor, and the fact that he was found with a firearm on his person in a stolen vehicle, Your Honor, we are requesting that the bond remains the same.
All right, Mr. Finley.
Yes, Your Honor. As stated, we are asking for a bond reduction. As we know, Mr. Lawson, as ASG Webb pointed out, he is presumed innocent. He is unable to pay this $5,000 surety bond, or anybody that's close to him is not able to. He does have strong community ties. He's originally from the Atlanta area, and his whole family lives here as well. While I do recognize the allegations and the open cases, as we heard, Mr. Lawson is presumed innocent on those cases. And as we know, bond is to ensure his return to court. Regarding that FTA, I did talk to Mr. Lawson, who is a young man, by the way. He's 18 years old. About that FTA and about how that works with contacting pretrial, and he took responsibility and just said that he didn't have the correct contact with pretrial, but ensured that would not happen again. And I really stressed to him the importance of returning to court. Leading up to this, he was working at McDonald's, Judge, trying to help his family as much as he can and himself. So we are asking for a bond reduction to $2,000 surety, Judge. I think you're on mute, Judge Vinci.
I'm sorry. I'm assuming, I don't know, as he lost that job at McDonald's, I wonder. How many days has he been incarcerated?
Odyssey just froze. 1 second. I was like literally pulling that up as we were.
1 second, Your Honor. I have it right here. It's been 16 days, Your Honor, as of today.
Okay. All right, I will reduce his bond to $3,000. Same conditions as the previous bond, and no drugs, alcohol, or weapons while on bond, Mr. Lawson. But I will reduce it to $3,000 surety bond. Oh, I'm sorry, $1,500 on each charge. I apologize. Is there anything else that we need to take up?
No,
Nothing
Judge.
further
Thank
from the
you.
site, Your Honor.
All right, thank you.
Next, we have position 1, Mr. Anina.
We still need to go in a breakout room for this case.
No, Your Honor. I just wanted to get the breakout room just with us to speak with him, but I did speak with him on the telephone, so we're okay.
Okay. All right. This is case number 19 DF 000100E. This is a case against is it Anemia? Not for sure how to pronounce the last name.
That's how you pronounce it.
Okay, Anemia. You're charged with is that 10 charges? all with the
Yes,
offense
Your Honor.
date on July 4th, 2018. First charge being DUI, driving under the influence less safe. Second charge, DUI, driving under the influence of drugs. Third charge, DUI, driving under the influence of glue, aerosol, or toxic vapor. Fourth charge, DUI, driving under the influence of alcohol and drugs. Fifth charge, emergency vehicle violation. Sixth charge, failure to yield right of way to emergency vehicles. 7, defective or no brake lights or turn signal. 8, HOV lane violation. 9, speeding, and 10, obstruction, law enforcement officer, all on the offense date of July the 4th, 2018. And what are we doing today, Ms. Webb?
Mr. Finley, I was waiting on your announcement on the
Yes.
case still.
Oh, yeah, I apologize. Yes.
Oh, you're on mute, Mr. Finley.
Sorry. This will be a negotiated plea, Judge. There were a couple little things I was going to ask on there, but negotiated plea.
Okay. And so, Ms. Webb, you can proceed and read the plea into the record.
Yes, Your Honor. The state's recommendation is going to be 12 months to serve 24 months to serve 24 days, credit for time served 12 days, balance probated, ADET, the Alcohol, Drug, and Evaluation Treatment Program, the VIP program, risk reduction for driving, a $750 fine, 2-day anger awareness, 2-day anger management courses, and 240 hours of community service. Your Honor, for this negotiated plea on the DUI, alcohol, speeding, and obstruction, our office will null process all of those additional moving violations, Your Honor.
All right, so we've got the negotiated plea on the DUI, alcohol, which is the first charge, and then speeding, which I think I read is number 8. And then the obstruction was number.
Yes, Your Honor. I think that was the final charge.
Yes, gotcha. All right. So, Mr. Anania, can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
And I want to remind you again that you have the right to remain silent, that anything that you state about the facts or occurrences of your case can and will be used against you, okay?
All right.
You may put your right hand down. I'm going to read you a series of questions that I need you to answer me regarding this proposed guilty plea or negotiated guilty plea.
Judge Mincy, when should I, because there was just a couple little things I wanted to.
Oh, I'm sorry, Mr. Finley. Let me let you go ahead first. I apologize.
No
Go
problem.
ahead.
No problem,
Okay.
Judge. No problem at all. Thank you. After speaking with Mr. Anania, he is a man that he and his family are pretty in a dire situation financially and have been for a long time, ever since his family came to America from Eritrea, which is in Africa. He currently has been sleeping on the couch in a family member's house. He works 12 hours a day. So this 240 hours community service, we are asking for that to be converted or some of that to be cut down and converted into a fine. So if it's an increased fine, he works 12 hours a day to support himself and his young daughter. That is just 200, that a community service would just be crushing him financially and just keeping him from being able to provide for himself and his family. So we would ask for a higher fine and reduction of that community service. Because like I said, he works 12-hour days. He works for Amazon packaging packages. So that's what we're asking, Judge. And also that once he does complete these conditions, if he can go on non-reporting, as this is a 24-month probation period.
Your Honor, I believe those hours were converted based off of the statute. This is the defendant's second DUI conviction. In accordance of 40-6-3391, upon the second conviction, Your Honor, there's a stipulated period of 30 days of community service. So the state isn't opposed to it being converted to 30 days, but I believe 30 days converts to that number of
Yeah,
hours.
30 days is 240 hours.
Yes.
Yeah.
It is statutory, Judge, so yeah, we
Right.
wouldn't be able to convert those.
Okay,
Would not, okay.
understood.
Okay. And so again, the 240 hours that we cannot convert, correct?
Correct, Your Honor, that is stipulated by the statute.
All right. So do you understand that, Mr. Anania?
Not really. If you could explain to me a little bit better, because, you know, the words y'all using, I really don't understand what y'all mean by that, man.
Well, it's mandated or set by the statute or by the law, and I don't have the liberty with that, with this being your second DUI conviction.
But I got 2 years to do the 240 hours.
24 months, correct. So you do have quite a bit of time to do it, but just don't let it catch up with you because time goes by fast. But yes, you would have 24 months to complete the community service.
So what about all them anger management class or whatever you're talking about? I got 2 days anger management class. You know,
Right.
I'm be able to do all that. I'm not be working my shift. I got that rotating shift, so it's like I'll be off one weekend and the other weekend I'll be having my daughter too. You hear me?
Right.
How I expect me to do all that?
Well, the 2-day anger management, I don't know if there are any that occur on the weekend or late evenings. There's that possibility to find one that is not during the day, but after working hours or on the weekends. And I don't know if ASG Web is aware of that or not, of whether there are evening or weekend anger
Yes.
management courses.
Your Honor, I'm not aware of far as the times, but far as I do know that they are pretty flexible in the office with getting that arranged. So I think he would just need to speak to his probation officer to see about that. But I believe they do have a flexible schedule, considering that most people do have to work.
Correct.
Probation will let him know on his first day of his appointment.
Great, thank you. Okay.
You're welcome.
They will work with you, Mr. Anania, to get that completed. Okay.
And also Judge, Mincy, if the probation fees could be waived, that's possible.
Any objection from the state on waiving the probation fees?
No.
Are you okay, Mr. Walker, with all or some or?
I would be okay with the first 6 months to be waived. Maybe that would serve as an incentive to completing all conditions.
And Judge, this opposition, the state doesn't really have a dog in that fight. It's a probation issue. It's for the court. I don't think their opinion really, right, is they shouldn't care one way or the other whether he has to pay the probation fees or not.
Yeah.
He's allowed to inquire, Mr. Howard.
Well, since this is a 24-month one, it's a little longer than normal. I'm going to waive half of it, which will be waive 12 months and he pay the other 12. So maybe you'll get it all done within the first 12. So I will waive 12 months of probation fees, okay?
All right.
And anything else?
And I'll be able to get out today.
You should when the jail releases you and make sure that you're clear to go, okay?
All right.
All right, so let me ask you these series of questions to begin to take your plea, okay?
All right.
Are you under the influence of any medication, drugs, or alcohol at this time?
No, Your Honor.
Are you satisfied with the services and representation of your attorney?
Yes, Your Honor.
Do you understand that by pleading guilty, you're giving up or waiving your right to the presumption of innocence?
Yes, Your Honor.
Do you understand that by pleading guilty, you're giving up and waiving your right to trial by judge or jury, whichever you prefer?
Yes, Your Honor.
Do you also understand that you're giving up or waiving your right to remain silent and not testify against yourself?
Yes, Your Honor.
Are you prepared and agree to waive all of these rights today?
Yes, Your Honor.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here?
Yes, ma'am.
And do you understand that do you offer rather this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, Your Honor.
And do you understand your conditions? You have 12 months of, let me go back over your charges. You're pleading guilty again to DUI under the influence of alcohol, less safe, speeding, and obstruction of a law enforcement officer. And all the other charges are going to be no cost, are not prosecuted. And
Yes,
so again, you will be on probation for 24 months to serve 24 days, credit for time served of your 12 days. Balance will be probated. You are to get an ADET evaluation, which is an alcohol and drug evaluation. And any recommendations that they give to you, you must complete those. You are to do a VIP, which is a victim impact panel, a risk reduction class, and $750 fine, and a 2-day anger management class. And you're also to complete 240 hours of community service. And the last thing is that I'm going to waive, order that the 12 months of your probation fees be waived. All right.
All right.
All right. So that is the plea, and good luck to you.
All right. Thank you.
Position 5, Mr. Curtis is next.
This is case number 21 CR 007226C, and it's Xavier Brown. Oh, wait a minute. I'm sorry.
Curtis.
Which position again? Oh, 5.
Five.
Okay, sorry. This is case number 21 CR 001668J. You're Orlando Antoine Curtis, is that correct?
Yes, ma'am.
Okay, you're charged with 1 count of criminal trespass with the offense date of August 26, 2020. And what are we doing today?
This is a negotiated plea, Judge.
Okay. All right, and let's see, Ms. Webb.
Yes, Your Honor. The state is recommending at 12 months to serve 14 days, credit for time served for 14 days, balance probated for restitution, Your Honor. And the defendant will have to pay restitution to adult, that's ADUT, or adult, Sophia Sophia Adult. That is Sophia SOPHIA at $200 for the loss of a cell phone or damage to a cell phone, Your Honor. Nothing further.
Okay. Mr. Finley.
Yes, Your Honor, and that is our understanding, and we do agree to the state's recommendation. And additionally, Judge, stipulate to the venue factual basis and ID.
All right, Mr. Curtis. You have heard the plea offer from the state as well as the conditions. Are you ready to take your plea?
Yes, ma'am.
You raise your right hand. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, you put your hand down. Want to remind you again that you do have the right to remain silent. And remember that anything that you say about the facts or occurrences of the case can and will be held against you, okay?
Well,
all right. And the first thing I need to ask you is, are you under the influence of any medication, drugs, or alcohol at this time?
no, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, Your Honor.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, Your Honor.
That you're giving up or waiving the right to remain silent and not testify against yourself?
Yes, Your Honor.
That you are waiving and giving up the right to trial by judge or jury, whichever you prefer?
Yes, Your Honor.
And that you are freely giving up these rights today, is that correct?
Yes, Your Honor.
And has anyone told you that you receive a lesser sentence for pleading guilty?
No, Your Honor.
Has anyone promised you anything to plead guilty?
No, Your Honor.
Do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes, Your Honor.
And do you offer this guilty plea freely, voluntarily, and with the full understanding of the charges against you?
Yes, Your Honor.
All right, I will accept your guilty plea, Mr. Curtis. And it is 12 months to serve 14 days, credit for time served of those 14 days. The balance will be probated for restitution. And so as soon as you pay that restitution to Sophia Adut or Adut of $200, then again, you will, I guess, go non-reporting for the rest of that time. Is that okay with everyone?
Can I ask a question, Your Honor?
Yes.
Okay, I have the money now to pay and my card downstairs. But I have a case already open here that they brought me here for.
Okay, probation, hold on a second. The probation department will speak with you and give you that information on paying that restitution. And then they will have to talk to you about any other matters. I'm going to defer and leave that to the probation department to talk to you about that.
And Your Honor, again, the probation was only for the restitution, so the state is not opposed to it being suspended once he does complete that restitution payment, Your Honor.
Okay,
That's exactly
so
what
we're gonna, okay, great, Mr. Finling. So we're going to suspend your probation. You will be off probation once you pay that restitution. Okay, is that clear? I see you shaking your head, so you understand that, all right? So the sooner you do it, the better, the easier, and then you'll be complete, okay?
Okay.
All right, good luck to you.
Next, we have position 17, Mr. Payton.
This is case number 22 CR 0000637Y, Victor Payton, and you're charged with 1 count of theft by shoplifting and a 2nd count of obstruction of a law enforcement officer. The first charge with an offense date of March 13th and the 2nd charge with an offense date of March 14th. And what are we doing today?
Judge, I also just want a clarification. When I looked up on the Odyssey, that theft by shoplifting came up as a felony. Could you verify if that's actually a misdemeanor or felony from March 13, 2021?
Ms. Grace, can you check that for me, please?
What I had, Ms. Helen, was that it was sent back to us as not a felony, but we can
Okay.
we can verify just for the record.
Thank you.
Right. Okay, so it was sent back, yes.
Judge, you're muted.
I was talking to my litigation manager. I'm sorry, hold for 1 second.
Oh, okay.
All right, I think we're back on the record. Ms. Helen and Ms. Duncan, it was transferred back to us, as Ms. Duncan said. So
Thank you, Judge.
we are okay. I think it was December 6th of last year, so we're okay.
Thank you,
All
Judge.
right. So go ahead and start, Ms. Duncan. Again, this is 22 CR 0000637Y. Victor Payton with 1 count of theft by shoplifting, offense date of March 13th, 2021, and a 2nd count of obstruction of a law enforcement officer with the offense date of March 14th, 2021.
Yes, Your Honor, it is my understanding from the announcement that this will be a negotiated plea. So the state is recommending for the 1st count of theft by shoplifting, 12 months to serve, 34 days, credit for time served, 17 days, balance probated, a theft class, 20 hours of community service, and a stay away from 4960, State Route 14 in Union City, 30291, which is a Family Dollar. And for the 2nd count of obstruction of a law enforcement officer, the state is recommending 12 months to serve, credit for time served, 34 days, my apologies. Credit for time served, 17 days, the balance to be probated, and 20 hours of community service.
Yes, Your Honor. And I do have one question for ASG Duncan. Are these running concurrent?
Yes, so we're looking for a total of, in terms of community service, 40 hours total. So yes, they are concurrent.
Yes, Your Honor. That is our understanding of the state's recommendation. We do agree to it, and we do stipulate to the factual basis, venue, and ID. We would just ask for the first 6 months of the probation fees to be waived, Your Honor. And then after that theft class is completed, if it could be non-reporting.
All right, Mr. Payton, can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
Okay, you put your hand down. Just want to remind you one more time that you have a right to remain silent. Anything that you state about the facts or occurrences of your case can and will be held against you, okay?
All right.
All right, after hearing the state's recommendations regarding this plea offer, I will accept the plea. And I need to ask you a series of questions and please answer for me. Are you under the influence of any medication, drugs, or alcohol at this time?
No, ma'am.
Do you understand that by pleading guilty, you're giving up or waiving your right to the presumption of innocence?
Yeah, ma'am.
Do you understand that by pleading guilty that you're giving or waiving your right to a trial by judge or jury, whichever you prefer?
Yes.
Do you understand that by giving up or waiving your right and pleading guilty that you have the right to remain silent and not testify against yourself?
Yes, ma'am.
And are you prepared to waive and give up these rights today?
Yes, ma'am.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you are currently on probation, your probation may be revoked because of your guilty plea here today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
Okay, and then so again, to the first count of theft by shoplifting, it's 12 months probation, 34 days to serve, credit for time served, which are 17 days, balance probated. You are to take a theft class and 20 hours of community service, and you're to stay away from 4960 State Route 14 in Union City, which is the Family Dollar. You are not to go back there. You don't want to get arrested again. And concurrently to run at the same time will be your probation for the obstruction charge. And again, that same 12 months, 34 days to serve, credit for time served at 17 days, balance probated, and 20 hours community service. So you actually have a total of 40 hours community service. And as soon as you complete those while you're on probation, then you will go non-reporting for the balance of those 12 months. So if you complete those 40 hours pretty quickly in 1 month, then you will go to non-reporting after that, okay?
Yeah, ma'am.
And then again, I will waive the first 6 months of your probation fees.
Okay.
All right, so you understand all of that?
Yes, ma'am.
Okay, all right, and good luck to you.
All right.
Thank you, Judge.
Thank you.
Thank you, Judge.
Mhm. We have anyone else in courtroom 2?
This is position 4, Mr. Brown.
Okay. This is 21 CR 0072226C. This is Xavier Brown. You're charged with 2 counts of theft by shoplifting, 1 with the offense date of May 20th, 2021, the second with the offense date of April the 7th, 2021. And I understand this is to be a negotiated plea.
That's correct, Judge.
Okay. All right, go ahead, Ms. Webb.
Yes, Your Honor. In Mr. Brown's case, the state is recommending 12 months to serve, 85 days, credit for time served, 85 days, balance suspended, and a stay away from Family Dollar located at 3031 Main Street, East Point, Georgia. Nothing for the my voice.
I understand. All right, Henley.
Yes, Judge Mincy, that is our understanding of the recommendation of which we agree. And additionally, we do stipulate the factual basis, venue, and ID.
All right. Mr. Brown, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
Okay. I'm going to ask you a series of questions regarding the plea that you've heard read by the state, okay?
Yes, ma'am.
And again, are you at this time under the influence of any medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up or waiving your right to the presumption of innocence?
Yes, ma'am.
That you're giving up or waiving your right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up or waiving the right to a trial by judge or jury, whichever you prefer?
Yes, ma'am.
Are you prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked because of this guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
All right, and again, the conditions are 12 months probation, confined 85 days, credit for time served, which are 85 days. Balance will be suspended, and you are to stay away from the Family Dollar at 3031 Main Street in East Point, Georgia. Please do not go there. You have to shop somewhere else, but you are not to return to that Family Dollar, or you will be violating your conditions of probation. All right.
Yes, ma'am.
And what I'll do is I'll waive the first 6 months of your probation fees. I'm sorry, suspended. My bad. It's credit for time served. That concludes it. There's nothing else for me to do in your matter because you're getting full credit for time served.
Okay.
Balance is suspended. So you will not be on probation, okay?
Okay.
All right, any questions or anything else I need to take up from Ms. Webb or Mr. Finley?
Nothing further, Judge.
Nothing further, Your Honor.
All right, thank you. Good luck to you, Mr. Brown.
All right, you too, ma'am.
Thank you.
Yes, she should be in 10. Hold on, give me 1 second, because I'm still doing a court right now. Hold on.
All right, anything else in courtroom 2?
Yes, that was it. Mr. Finley, I have Mr. Curtis over here. Did you need, you said you need his information?
Yeah, no, I was just, it looks like I just got a message. Probation just needed contact info
So
for,
you need this information right here that I see on the chat?
yeah, I believe that's, yeah, so I'm gonna, or no, sorry, so that's saying, that's the court's number, that's not the person's number, is it?
No, I see it says, report to 132, but it says Mr. Brown. That's okay.
No, so I'm gonna call this number right now. I'm gonna call the courtroom.
Disregard Mr. Brown because his probation is been suspended. That is suspended.
Mr. Brown is suspended.
Yeah, probation just needs contact info with Mr. Hold on 1 second.
With the victim, for the victim
Yeah,
on
for
the
the victim,
restitution.
so she can be paid that $200 restitution.
Okay, so disregard this text.
Or yeah, add it, so add it Sophia, so for Mr. Curtis.
Francois, disregard Mr. Brown.
Okay, thank you. Okay, we're completed here in courtroom 2.
All right.
Mr. Finley,
Yeah.
Mr. Curtis wants you to give him a call.
Yeah, I'm gonna call right now. I'm gonna call the courtroom.
Okay, thanks.
All right, thank you.
We're
Thank you,
completed here,
Deputy.
Judge. Thank you.
Yes, thank you. Have a good day.
Thank you too.
South Annex.
Yes, ma'am, we're here. I have Miss White here, Miss Burgess. I'm sorry, Miss Wilder and Miss Gaston.
Okay, so you have Brianna White, Shamika Wilder, and the third person is Gaskin.
Gaskin, yes. In front of you is Miss White.
Okay.
And that's a negotiated plea, Your Honor.
Okay. Miss Brianna White, this is case number 22 CR 001126G. Miss White, you're charged with 1 count of criminal trespass and a 2nd count of obstruction of a law enforcement officer, both with the offense date of February 28, 2022. And go ahead, Ms. Duncan.
Yes, Your Honor. For this case, the state has a global recommendation of 12 months to serve, 32 days, credit for time served, 16 days with the balance suspended, and to stay away from the Citgo at 3657 Martin Luther King Jr. Drive.
Yes, Your Honor, that is our understanding of a recommendation. We do stipulate to the factual basis, venue, and ID. And I do believe that the remainder is suspended, so.
Right. All right. probation. Got you. All right. Miss Brianna White, can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under your penalty of perjury?
Yes, ma'am.
Okay. And I want to remind you that you do have a right to remain silent, that anything that you state about the facts or occurrences of your case can and will be held against you, okay? Let me ask you a series of questions now that you've heard the plea read by the state. Are you under the influence of any medication, drugs, or alcohol at this time?
No, but is the plea time served?
Yes.
Okay.
And the balance is suspended, so you don't have any probation, okay?
Yes, ma'am.
Okay. And are you satisfied with the services and representation of your attorney?
Absolutely.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
I do.
Do you understand that by pleading guilty, you're giving up or waiving the right to remain silent and not testify against yourself?
That's correct, Your Honor.
That you're giving up or waiving the right to trial by judge or jury, whichever you prefer?
Also correct.
Are you prepared and agree to waive these rights today?
Correct, Your Honor.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, that wasn't happening.
Has anyone promised you anything to plead guilty?
They did not.
Do you understand that if you're currently on probation, your probation may be revoked because you're pleading guilty today?
Understood.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
I do.
And so as to the charges of criminal trespass and obstruction of a law enforcement officer, how do you plead?
That would be guilty.
Okay. And so again, the conditions are that it's 12 months, 32 days, credit for time served at 16 days, balance suspended, and you're to stay away from that Sitco on 3657 Martin Luther King Jr. Drive. Please do not go there so that you will not be arrested again. Just avoid it forever almost. So can you do that?
Yes, I can.
Okay, good. And so that completes your plea, and good luck to you, okay?
Thank you, Your Honor.
All right.
Thank you, Judge.
Uh-huh.
Wow. Next, Your Honor, is Ms. Wilder.
Okay. This is Shamika Wilder, case number 19CR009387C. You're charged with 1 count of simple battery family violence with the offense date of July the 3rd, 2019. Is that correct? And is this going to be a plea as well?
This is going to be a non-negotiated plea, Judge. Jail time at issue.
Okay. All right, Ms. Duncan?
Yes, Your Honor. The state had recommended 12 months to serve 30 days, credit for time served 14 days with the balance suspended, family violence intervention program, no further contact with Lester Johnson, and a stay away from 291 Hamilton E. Holmes Drive, which is the Atlanta Berean Seventh-day Adventist Church. We would just ask that our recommendation be accepted given the facts and circumstances in this case. This defendant does have a prior battery, family violence, and cruelty to children in the third conviction from 2019, as well as an arrest for battery domestic violence in May of 2012, and an FTA from November 2019. In this case, the defendant and her, I believe her husband, Lester Johnson, were in a physical dispute, and they began to argue while driving in the vehicle, and they pulled over into the incident location. The victim exited the vehicle in an attempt to enter the church. And while the victim, in this case, Mr. Johnson, was attempting to enter the church, the defendant began to attack him, and which resulted in injuries to his body and face. The church staff at the time advised the officers that the defendant approached the victim and began actively fighting him on the church property. There is surveillance video of the incident, and the video, according to the officer, showed the victim attempting to enter the church and the defendant approaching the victim and arguing on the church steps. And it also shows that the victim was hit in the back of the head as he was attempting to walk away from the defendant. In this case, he was struck, as I said, in the back of the head. And a dispute ensued. We are concerned with the risk of reoffending due to her violent history and as well as her previous convictions. We request that our recommendation being accepted. It just adds one additional day, I believe, if my math is correct.
All right, Ms. Helen.
Yes, Judge, this is a non-negotiated plea. We are asking for time served. The state is correct. They're asking for an additional day. However, when I spoke to Ms. Wilder, she gave a little bit more of a background to what happened. She was homeless with Mr. Johnson, and 1, 2, 3, 4, 5, 6, 7, 8 of their children at the time. And as they were living homeless out of the vehicle, an argument ensued. Ms. Wilder would like to be released because she has secured housing since this incident for her and her children. She does share 3 children with Mr. Johnson. Mr. Johnson, to my knowledge, is incarcerated at the moment. We would ask this court if that could be a no violent contact with Mr. Johnson, because again, they do share 3 children. Mr. Johnson, I do believe, is still reaching out to Ms. Wilder. Again, when I spoke to Ms. Wilder, she just mentioned to me that it was an argument at that point, that they were residentially challenged with several of their children. So we are asking for it to be time served. We are asking for it to be no violent contact so that Mr. Johnson can have some interaction with his 3 children that he shares with Ms. Wilder. If the state is not amenable to that, we are just asking for third-party visitation so that those 3 children that they do share can see their father. Judge, we were also asking for the fees, the probation fees, to be waived. Again, we are asking for the full 12 months. After speaking to Ms. Wilder, they have put all their resources into that apartment for their children, and they just want to make sure that they can financially afford that, Your Honor. We do have that address of 3002 Ember Drive Apartment, Decatur, Georgia 30034 as a stable address. Again, Judge, I do believe that they're currently married. I know that he's not here to speak as the alleged accuser, but we are asking for no violent contact so that he can have contact with the 3 children. And we are just asking for it to be time served with the fees to be waived, Your Honor.
Okay. I will accept the plea. I will go ahead and order credit for time served so that she can be released. She won't have to serve another day. I'm going to also waive all of the probation fees. And I am going to order, as far as contact with the victim, I think you said only 3 of the children were his. There's definitely, I think that there should be no further violent contact so that the children can visit with their father.
Your Honor, given her history, we would ask for a third-party contact.
Okay, and I'm sorry, I did write that down, but yes, let's do third-party facilitator for the visitation of the children, so that we have someone else involved to help facilitate that smoothly. Okay. All right, Ms. Wilder, I'm going to go ahead and ask you a series of questions to accept your plea. Can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury? Can you hear me?
Yes, ma'am.
Okay, all right. And you can put your hand down. Want to remind you that you have a right to remain silent. Anything you say about the facts and occurrences of your case can and will be used against you, okay?
Yes, ma'am.
Are you under the influence of any medication, drugs, or alcohol at this time?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're waiving and giving up the right to a trial by judge or jury, whichever you prefer?
Yes.
And that you're ready and willing to waive those rights today?
Yes.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
Not at all.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea today?
Yes, I understand.
And do you offer this guilty plea freely, voluntarily, and with the full understanding of the charges against you?
Yes.
All right, I'm going to accept your plea of guilty to the simple battery family violence. The conditions are 12 months probation, 30 days to serve, but credit for time served at 14 days. The balance will be probated. You're to take the family violence intervention program, which I believe is 24 weeks. You're to have no further violent contact with the victim, Lester Johnson. You are to stay away from 291 Hamilton E. Holmes Drive. And in order to facilitate visitation with the children and the victim, Mr. Lester Johnson, you're to have a third party person to help facilitate that visitation. But I'm not going to make you serve the extra day.
Thank you.
All right, and then all probation fees are waived.
Thank you.
Okay, all right, good luck to you.
Thank you, Judge.
Uh-huh.
Next, Your Honor, we have Ms. Gaston.
Okay. This is case number 21 CR 0000227H. Tony Gaston, you're charged at 1 count of simple battery. The offense date is January the 14th, 2021. And this is a plea as well?
Yes, Your Honor, this is a negotiated plea.
That's correct, Judge.
All right, Ms. Webb, you may go ahead and proceed.
Yes, Your Honor, the state is recommending for Ms. Gaston 12 months to serve 121 days, credit for time served 121 days, balance probated, no further contact with Charles Barlow, that's Charles common spelling, Barlow, B-A-R-L-O-W, a stay away from 4805 Main Street, Union City, Georgia, and 6-week anger management courses. Nothing further, Your Honor.
All right, Mr. Finley, is that your understanding of the plea?
Yes, Your Honor. That is our understanding of the state's recommendation. We would just ask if the probation fees could be waived, as finances are a steady issue in Ms. Gaston's life, as well as once she does complete the condition of the anger management course, if she can be not reporting judge. And additionally, I do stipulate with the factual basis, venue and ID.
All right. And Ms. Gaston is not working at this time. Mr. Finley?
Sorry, I was on mute. No, she does not have a job at this time, Judge.
Do you have any children?
She does, believe was one child.
She's raising her hand.
Ms. Gaston, what was
I have 4 in the
4
children of Barlow.
4 children, and what else did you say, Ms. Gaston?
The last 2 are Barlow's children.
I'm sorry. Yeah, I do have that written down. I'm sorry. She does have 4 children.
Gotcha. and then 2 belong to the victim, 2 of his children. All right, thank you for that. All right, if we're clear, Ms. Gaston, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down. And I want to remind you again that you have a right to remain silent. Anything that you state about the facts or occurrences of your case can and will be held against you. I'm going to ask you a series of questions in order to accept your plea. The first one being, are you under the influence of any medication, drugs, or alcohol at this time?
No.
Are you satisfied with the services and representation of your attorney?
Yes.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes.
That you're giving up or waiving the right to remain silent and not testify against yourself?
Yes.
That you're waiving and giving up the right to trial by judge or jury, whichever you prefer?
Yes.
And are you prepared to agree and waive these rights today?
Yes.
And has anyone told you that you would receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
No.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes.
Okay. All right, I will accept your guilty plea and I will review your conditions again. 12 months to serve 121 days. Credit for time served at 121 days. Your balance will be probated. You're to have no further contact with Charles Barlow. I'm going to add one other condition, is that to exchange visitation with the children, that there be a third party to help facilitate that, so that we make sure that everybody is safe, okay? So if you allow visitation, you have to have a third party to help control or facilitate that, okay?
Mm-hmm.
And you are to stay away from 4805 Main Street in Union City. And you're to complete a 6-week anger management course. And so you can go non-reporting after completing the 6-week anger management course. And I will waive half of the 6 months of the probation fees. Okay?
Repeat that last one.
I will waive 6 months of your probation fees, or half of those.
Yeah.
I'm sorry. Did you have a question? Okay, would you be able to pay the other 6 months?
No. I have
Okay.
to take care of 20, they 7 months.
Okay, I will waive all of your probation fees, okay, for the 12 months. You have that, Ms. Graves. Okay. All right, is there anything else I need to take up, Mr. Finling or Ms. Webb?
Nothing further, Judge. Thank you.
All right, good luck to you, Ms. Gaskin. Don't forget your 6-week anger management course. Get started on that. Sooner you get it done, the better it'll be, okay?
Thank you.
All right, you're welcome.
That'll be all for South Annis, Your Honor. Can we be dismissed?
Yes, you may. Have a good afternoon.
You too, ma'am. Thank you.
Uh-huh. We'll sign these two and then we'll reconcile in a minute. Yeah, I think, is that everybody? I believe the others, we've got quite a few have been released and reset. Yeah,
I was told to hold for position 21.
hold for 21, okay. Oh, I see, okay.
I don't know if they called Mr. Walker. I don't know what courtroom he's in. So as soon as he appears, that's position 2021.
Yeah. Okay.
I'm
Yeah.
holding on from 3/16/19.
3 was released. And 16 is reset to 3/17.
No, I put a chat in for this. It had to go to 3. That's what it is. 3/24 because that calendar for Thursday's already been sent out and she didn't come back.
Oh,
Tell me.
okay.
So can you make an announcement for that? You set to
Right, position
24, 16.
Yeah, so
That
position
calendar's already been
16,
sent out.
I have on my notes that it was reset for the competency calendar for 3/17.
That's correct,
Um,
Judge.
But I'm hearing the calendar's already gone out and that case is not on it, so it will be reset to 3/24.
The 3/24, okay.
In your honor, speaking of the competency calendar, I do have an update on position 26. I'm not sure if Mr. Howard is still on the line.
Let's see, Mr. Howard, are you still there?
Yes.
Okay.
So on position 26, we did review Odyssey. It looks like an order has already been placed, so that will need to be placed on the 3/24 competency calendar.
Yes, Judge. Mr. Walker and I talked about it, so we'll pick it up there.
Yeah, I think we initially reset it for like jail, bench or
Jail
something.
Did or something. Mhm.
So
We're gonna
3/24
reset to 3/24. Okay.
competency calendar. Thank you, Your Honor.
Thank you.
Position number 26.
Yes, 26 reset to 3/24 as well.
That's going on.
For position 19, Your Honor.
Uh-huh.
I spoke with his private attorney. He told me that they appeared in person and they were excused because his defendant is not in custody.
Right.
Position number 19, they were released.
Yes, that defendant was released. Correct. We have that. Thank you.
So I got 21 and 27.
So 21 and 27 are the only two we're waiting on.
And then I need for you to go over position number while they hold.
27 was announced to me as released, Your Honor.
Oh, let's see. You're right.
Correct. 27 is released.
27 is released. And then I have 21, 21 not coming out.
Yes, Judge, if the deputies just told you Mr. Walker isn't coming out, then yes, we're gonna have to reset that. And I may need to talk to Attorney Howard. We may have to reset it to the competency calendar.
Okay.
The jail has signed off.
Right, so he obviously isn't coming. So we'll, do you all want to reset it to the competency on 3/24?
Yes, Judge.
Okay.
And just so we're clear on that position, PD Helen, will you be submitting a competency order? Because that's only for cases where orders have been submitted.
I will.
All right, thank you.
Thank you, Mr. Walker. Let's see, I'll sign these. Yeah, 25 is a medical reset to 3/22.
Yes, Judge.
Let me do this one. Yes, we can go ahead and I'll finish these up. When we get done.
Okay. Position number 1 was a guilty plea. Position number 2 reset to 3/22 SAP. Position number 3 was released.
Position number 4 and 5 were guilty pleas. Position number 6 is reset for 4/11/22 competency calendar. Position number 7 was released. Position number 8 and 9 reset the 3/22 SAP calendar. Position number 10 was a plea. Position number 11 reset jail jury. Position number 12 reset jail jury. Position number 13 reset 3/22 SAP. Position number 14 reset jail jury. Position number 15 reset jail jury. Position number 16 reset 3/24 competency calendar. Position number 17 was a plea. Position number 18 was a plea. Position number 19 was released. Position 20 was a plea. Position 21 reset 3/24 competency calendar. Position 22 was released. Position 23 was a plea. Position 24 was a plea. Position 25 reset 3/22 SAP. Position 26 reset 3/24 competency calendar. Position 27 was released.
All right, any correction?
And I just want to clarify, that means for position 26, no bond modifications granted. He's just being reset to the competency calendar for the 24th.
Correct.
Okay, thank you.
So you
Thank you.
need to send over that order for the bond.
Right, because now on that one, I think I talked about the 2,500. Was that a reduction?
Yes,
Yeah.
It was.
So I would need that order still.
Right, let's go, well, we'll. That was before we had decided to reset him to 3/24, correct?
Right, and I apologize. We didn't check Odyssey, but once we checked Odyssey, we realized the order had already been filed on March 1st.
Okay, so I'll leave his bond as is.
Okay,
I will not reduce it and then reset him to 3/24.
understood.
Thank you for that clarification. So does that conclude all of our business today?
Believe so.
Believe so? All right, you all have a good afternoon. Good to see everyone.
And we're
All right.
sending everything to Melissa Grace, right? Melissa, okay, thank
Yes,
you.
Melissa Grace, yes. She's
All right.
waiting.
Thank you, Your Honor.
All right, thank you, everyone.
Thank you.
All right, bye-bye.